What's the surprising history of insolvency laws? Imagine a time when failing to pay your debts could land you in jail or cause your property to be seized without mercy. That was the reality in early legal systems. Insolvency laws have a long history that shows how society's attitude toward debt has changed over centuries. Back in the days of early English common law, which influenced many countries including the United States, debtors who couldn't pay faced harsh punishments. They could be thrown in jail or have their property taken and given to creditors. People saw insolvency as a moral failing or even a crime, not just a financial problem. As time went on, laws began to shift. The United States Constitution gave Congress the power to create uniform bankruptcy laws. The first federal bankruptcy law was passed in the year 1800. Early laws mainly targeted traders and involved involuntary proceedings, which meant creditors could force debtors into bankruptcy. But these laws were limited and often unfair. Over the 1800s, reforms started to appear. Debtors gained more protections, and voluntary bankruptcy became possible. Laws like the Bankruptcy Act of 1898 marked a turning point. They focused on resolving debts in an orderly way rather than punishing debtors. Insolvency laws also moved from being controlled mainly by creditors to a court-supervised process. Courts appointed officials called trustees or assignee to manage insolvent estates. This change helped reduce corruption and conflicts of interest. Another important shift was unifying the legal treatment of traders and non-traders. Before, they were treated differently, but laws were simplified to cover everyone equally. In the 20th century, laws kept evolving to reflect economic realities. They included protections for small business owners and introduced options like debt repayment agreements called compositions. The idea of giving people a fresh start became more prominent, especially after a 1930 Supreme Court decision in the United States. More recent laws, like the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, aim to balance helping honest debtors while preventing abuse of the system. Looking at this history, it's clear that insolvency laws have come a long way. They started as harsh punishments and creditor-controlled processes. Today, they are designed to help both creditors and debtors recover and rebuild financially. These laws support economic stability by offering a fair way to handle financial failure and give people a chance to start over.